Hello, this is Professor Emeritus Harry Flechtner from the University of Pittsburgh School of Law, and I'm here today to talk to you about the substantive issues in the 28th vis moot problem. I start, as I believe Professor Brand tends to start also, we've done this for a while, not at the beginning of the problem, but at the end in procedural order number 1, which defines the issues that the parties are supposed to address. These issues sometimes get modified, changed, massaged a little bit in procedural order number 2, but that comes out later on. But they are usually the main issues that you should be discussing. And according to procedural order number 1, here are the issues that are relevant in this year's moot, the substantive issues that I'm going to talk about, the CISG-related issues. The first substantive issue is whether the CISG is applicable to the purchase, collaboration, and license agreement, that was concluded between claimant and respondent number 1. The second issue, substantive issue, is whether respondent number 1 has breached its contractual obligations to deliver conforming goods that exist pursuant to Article 42 CISG when it provided claimant with the batches of GORADCAM viruses. So let's begin with the first substantive issue. Does the CISG apply to the purchase, collaboration, and license agreement between claimant and respondent number 1? I will say that I think this is a challenging, rather complex, rather complicated issue to address. The main CISG applicability provision is Article 1.1. It provides that the convention applies to contracts of sales of goods between parties whose places of business are in different states, when the states are contracting states, or when the rules of private international law lead to the application of the law of a contracting state. Before we get into this, let me bring up an issue. That is, what is the effect of the clause 15.2 in the purchase, collaboration, and license agreement between the parties, which is found in the record on page 16. There is a choice of law clause there, and it provides, quote, this agreement shall be construed in accordance with and governed exclusively by the laws of Danubia. Now, Danubia, we are told in procedural order number 1, page 52, that it is undisputed between the parties that Equatoriana, Mediterraneo, and Danubia are contracting states of the CISG. In other words, each of these states has ratified the CISG, and it is in force in the CISG. So these kinds of choice of law clauses, which chooses generally the law of a contracting state to the CISG, they have been quite consistently interpreted to mean that if a particular contract falls within the applicability provisions of the CISG, Article 1, that the CISG will be the applicable law, that this is not a choice of domestic sales law as opposed to the CISG, because the CISG is part of the domestic laws of Danubia. So I do not think that the choice of law clause will interfere with our discussion of the applicability of the CISG under Article 1. It has been sometimes suggested that this kind of approach makes such choice of law clauses meaningless. I mean, the CISG would apply without this choice of law clause. So is that a proper interpretation? If it doesn't have any effect, the fact is it does have an effect. And the effect is indicated by paragraph 3.3, which is found on the record page 52 in procedural order number 1, which provides that the general contract law of all 3 countries, that includes Danubia, Equatoria, and Mediterranean, is a verbatim adoption of the UNIDROIT principles on international commercial contracts. So where there are issues that are beyond the scope, not governed by, not provided for by the CISG, those matters will be governed by Danubian law, and in the area of contract law will be the unidroit principles on international commercial contracts. So the choice of law provision has that effect. It designates Danubian law, which includes the CISG, but for things beyond the CISG, Danubian domestic law for other matters. So the first question, under Article 1.1 of the CISG, there are 3 requirements for the CISG to apply. It must be a contract for the sale of goods. The parties must be located in different states, and those states must, and I call this last requirement the nexus requirement. Nobody else does, but I do. That can be satisfied in alternative ways. The final requirement is whether both Mediterraneo and Equatoriana, the places where the parties are located, are they contracting states to the CISG? The answer to the first question, are the parties places of business in different states? The answer is, as far as we know, apparently yes. From the Purchase, Collaboration, and Licensing Agreement, which is Claimant's Exhibit C3, which is found on the record, page 11. Quote, Respivac, a corporation organized and existing under the laws of Mediterraneo, with a business address in Mediterraneo, and Camvir, a corporation organized and existing under the laws of Equatoriana, having a business address in Equatoriana. Those are the parties to the agreement. Those are 2 different states, Mediterraneo and Equatoriana. Article 10A of the CISG provides you some further guidance concerning the location of the relevant parties' places of business, but I don't see much of an issue regarding this. It appears that this is a situation where it's an international sale as defined in the CISG, which means a contract between parties located in 2 different states, in this case Mediterranean and Equatoriana. The nexus requirement is satisfied, it seems, because according to Procedural Order Number 1, on page 52 of the record, quote, it is undisputed between the parties that Equatoriana, Mediterraneo, and Danubia are contracting states for the CISG. So Equatoriana and Mediterraneo, where the parties are located, are both contracting states of the CISG. So that would appear to satisfy the nexus requirement under Article 1.1a. So what's the issue? What requirement is left for the CISG to be applicable under Article 1.1a? Remember that Article 1.1 requires a contract for the sale of goods. So the question is the purchase, collaboration, and licensing agreement between claimant and respondent such a contract for the sale of goods? In fact, there are 2 issues hidden, you might say, within the contract of sale of goods requirement in Article 1.1. First of all, the contract must be a contract for sale, and second of all, the subject matter of the sale must be goods. So, for example, a contract for a 1-year lease of goods would satisfy the second requirement. The subject matter is goods, by definition. But not the first requirement, because a lease is not the same thing as a sale. Similarly, a contract for the transfer of ownership of non-goods, such as real estate or intangible patent rights, that would satisfy the first requirement. It is a sale of those rights. It is, as we will talk about in a moment, but not the second requirement, because the subject matter is not goods in those cases. The CISG does not expressly define the terms sale, contract of sale, or goods. Nevertheless, you should be able to locate authority. You really should be able to, suggesting that a sale means transfer of ownership for a price, transfer of ownership of something for a price, and goods means something tangible as opposed to abstract or intangible other than real property. So a sale of goods would be the transfer of ownership for a price of something tangible other than real property, not an intangible such as just the patent rights themselves. So the first substantive issue, continuing, does the CISG apply? We now focused on the requirement that seems to be at issue, is this a contract for the sale of goods? How do the parties frame this issue in their documents? Well, claimant's notice of arbitration, which is found in paragraph 25 on page 8 of the record, it just asserts that, and here's the quote, the collaboration and licensing agreement is governed by the CISG as it involves the sale of goods. Just a pure assertion, no support for that. On the other hand, respondent's answer contains a little bit more argumentation, you might say. Paragraph 19, which is found on page 28 of the record, provides, and this is from respondent's answer, paragraph 19 of respondent's answer, the collaboration and license agreement falls outside the scope of the application of the CISG as defined by Articles 1 through 6 of the CISG. It is no contract of sales, but despite its misleading name, quote, purchase, collaboration, and licensing agreement, it is a licensing agreement as the transfer of know-how is by far the most important obligation for respondent number one. So the argument is that the transfer of know-how, which is an intangible, it's not a tangible item, that is the most important obligation, and that means this is not a sale of goods. Now, Article 3 of the CISG may address, directly or indirectly as it turns out, some of the issues as to the applicability of the CISG in the situation we are dealing with. Article 3.1 provides that contracts for the supply of goods to be manufactured or produced are to be considered sales unless the party who orders the goods, which would be the buyer if it turns out to be a sale, unless the buyer undertakes to supply a substantial amount of materials necessary for such manufacture or production. An example of this kind of situation from a U.S. case was one where the buyer party entered into a contract for the printing of its logo on shopping bags. It was a retail store, provided for its printing of logo on shopping bags, and the buyer provided the actual shopping bags on which the logo was to be printed. The only tangible thing the seller provided was the ink used to print the bags, and the court in that case said it was not a contract for sale of goods within the meaning of U.S. law. That's not necessarily particularly relevant of the CISG, but an example for you. So, respondent's answer does not appear to raise any issue based on the fact that the deliverables under the purchase, collaboration, and license agreement, may have to be manufactured or produced after the conclusion of the contract. The argument in this case that Article 3.1 addresses is that if you enter into a contract for someone else to produce in the future goods, you're not really buying goods, you're buying services, manufacturing services. But Article 3.1 rejects that argument unless the buyer or the party who orders the goods is supplying a substantial part of the materials for that. Respondent's answer does not appear to raise any issue based on this, and you may not want to trust me on that, but at least that seems to be preliminarily true. By the way, respondent's answer may not raise this issue, but this arguments frequently diverge from the party's original position in the problem. It's always a little interesting moment in the arguments. Are you amending your complaint? Are you amending your answer? But very frequently, as a result of pre-moots and working through the problems, different arguments come up than the ones expressed in the parties' filings. To the extent that the purchase, collaboration, and license agreement involves services, Article 3.2 provides, the convention does not apply to a contract in which the preponderant part of the obligation of the party who furnishes the goods, which would be the seller if it's a sale of goods, consists in the supply of labor or other services. So this is a rule concerning the so-called mixed contracts, where the contract provides for both the transfer of ownership of goods and services to be provided by the, quote, seller. of the goods. And it articulates the preponderant part test. Does the sale of goods, is that the preponderant part of the contract, or is it the services that is the preponderant part of the contract? And by the way, if you want to know about Article 3, you certainly must consult the CISG Advisory Council Opinion Number 4, which is available at the URL that is given in the PowerPoint that I've provided for here, which is a thorough discussion of Article 3 and suggests a methodology for determining how one determines what is the preponderant part of the obligation. But respondent's answer does not frame the issue in terms of goods versus services, as would be covered by Article 3.2. Respondent's answer emphasizes the allegedly predominant intellectual property focus of the agreement. Now, that may not be goods, but it's not necessarily services. So we have something that's not expressly perhaps not expressly addressed in Article 3.2, but raises the issue of whether this is a contract for the sale of goods. Respondent's answer suggests an argument that the issue is whether the agreement is predominantly about a license of intellectual property rather than a sale of goods, which is an issue not directly addressed in CISG Article 3.2. How should one approach such an issue when it is not expressly addressed in the Convention? Nothing in the Convention expressly addresses this. Perhaps see Article 7.2, which deals with gaps in the Convention, but I've got to say, when you're talking about an issue concerning the applicability of the Convention, it seems to me you have to interpret the Convention itself to fill the gap, not just try to go to the general principles of the Convention, or perhaps even to applicable non-domestic law. I don't know what, applicable domestic law. I don't know what domestic law's rules about whether these intellectual property matters constitute contracts for the sale of goods. I don't know what they are, but I don't see why the rules for whether domestic sales law should apply to a particular contract have much to do with whether the CISG should apply to that contract. So it's kind of an odd thing. One might argue that Article 3.2, pursuant to CISG Article 7.2, suggests a general principle that the application of the CISG should depend on whether the sale of goods or a sale or non-sale of non-goods preponderates in the contract. The issue would be what is predominant, as it is in the case of combined goods and services contracts. And here, note the phrasing of respondent's answer. That is the purchase and licensing agreement, is no contract of sales, but despite its misleading name, Purchase, Collaboration, and Licensing Agreement, a license agreement as the transfer of know-how is by far the most important obligation for respondent number 1, and that is respondent's articulated argument that the CISG does not apply. That the most important obligation in this contract is not a sale of goods, and that means that it is not governed by the CISG. There's some other considerations when you're doing all this. In cases of doubt, should arbitrators favor applying the Convention in order to advance the cause of uniform international commercial law, an interpretation pro convenzione, that is, in favor of applying the Convention? You will find authority for such an approach. On the other hand, if the CISG was not designed to deal with the kind of contracted issue here, it does not make sense to apply it, just in order to favor uniform commercial law. So, yes, some interesting policy as well as practical issues to deal with here. Based on respondent's answer, the ultimate issue is whether the purchase, collaboration, and licensing agreement between claimant and respondent, number 1, is primarily or predominantly a sale of goods, or primarily or predominantly a license of intellectual property. That's the way respondent phrases it. Although, again, the positions taken by the parties in their original filings is not always the way the issue tends to be framed in the actual arguments at the moot. I suspect, more than suspect, I'm sure, that to address issue number one, you all will have to acquire a much more detailed and accurate understanding of these kinds of transactions than I have at this point. But an important query, an important question: what difference does issue number one make? If the CISG does not apply, what law does apply? And under that law, what is the approach to issue number two, which is really the grabber issue in this case, the issue for an actual remedy in this case. So if the CSG does not apply, what law does, and what does it say about the question of whether there has been the seller has violated its obligations because of questions about its right to grant intellectual property in the contract. So I'm attempting to summarize some of the things I've said, and there's a lot more that could be said about this and will be said when you get into it. First, is the transaction in the purchase, collaboration, and licensing agreement a contract of sale of goods governed by the CISG? And as part of that argument, to what extent is the issue governed directly or by analogy by CISG Article 3? If it is not governed by CISG Article 3, what is the applicable legal rule and how does it apply to the substantive issue in the case concerning whether the seller has violated its obligations? What are the legal consequences if the CISG does not apply? You must look carefully at the terms of the purchase, collaboration, and licensing agreement, identify those specific aspects that arguably constitute sales of goods, and compare them to the non-sales aspects in order to fashion arguments on these issues. Pardon me. The second substantive issue. If the CISG applies, suppose the CISG does apply, did respondent number one breach CISG Article 42 by granting claimant a license that might be challenged, perhaps unsuccessfully, but perhaps successfully, by Ross? Here is claimant's argument on the point from its notice of arbitration in paragraphs 26 to 28 on page 8 of the record. 26. In the present case, the use of the GOR-ADCAM viral vectors may, however, be potentially restricted by an IP right of Ross Pharmaceuticals, to which respondent number 2 seems to have granted an exclusive license for all malaria-related usages and, quote, comparable infectious diseases. By the way, we have, I believe, the actual language from the license to Ross Pharmaceuticals in Respondent's Exhibit 3, starting on page 32, and that language is malaria and related infectious diseases, not comparable infectious diseases. Does that make a difference? Well, for you to find out. You can find that in clauses 1.3 and 2 of that agreement on page 32. On the other hand, apparently when claimant initiated arbitration and had to figure out what claims to make, it was not aware, could not have been aware necessarily of what the language in that agreement was. If you can hear my dog barking, it's probably more interesting than me. Okay. According to the interpretation of the Ross agreement by Ross Pharmaceuticals, I'm back to the claimant's notice of arbitration. According to the interpretation of the Ross agreement by Ross Pharmaceuticals, the license also covers the research into a vaccine against COVID-19. Whether that is actually the case, as respondent number 2's press release seems to imply, referencing claimant's Exhibit C, or not, is irrelevant. Already the mere claim of a third party, which is not completely baseless, is sufficient to render the goods non-conforming in the sense of Article 42.1 CISG. In particular, for small startups like claimant, which focus their whole work on one product, certainly concerning unrestricted ability to use the viruses delivered is of crucial importance. Due to the limited funding and manpower already, the mere threat of a lawsuit, irrespective of its final outcome, seriously prevents an unaffected use of the goods delivered. So, even if it turns out that Ross's claim or Ross's right does not interfere with claimant's right to use the virus. Claimant argues the mere threat, the mere cloud of uncertainty that it creates is enough to constitute a violation of Article 42 of the CISG. Well, respondent's response in paragraph 20 of its answer, which is found on page 28, even if the CISG were applicable, which it is not, respondent would not have breached its contractual duty to deliver goods which are free from any right or claim of a third party based on industrial property. There is clearly no IP right of Ross Pharmaceuticals, nor has such a right ever formed the basis of a claim raised against the claimant. So, Ross has never made a claim against the claimant. Ross has, and respondent argues that there clearly is clear that there is no IP right of Ross that would interfere with claimant's use of the license that it has. Thus, the issue is whether a claim, in this case a claim of patent infringement by Ross against claimant, that has not yet been adjudicated or even asserted, is a violation of respondent's obligations under CISG Article 42. Well, let's take a look at Article 42 since we're talking about it. 42.1 is the part that we're most interested in. The seller must deliver goods which are free from any right or claim of a third party based on industrial property or other intellectual property, of which at the time of the conclusion of the contract the seller knew or could not have been unaware, provided that the right or claim is based on industrial property or other intellectual property. A, under the law of the state, that the claim arises under the law of the state where the goods will be resold or otherwise used if it was contemplated by the parties at the time of the conclusion of the contract that the goods will be resold or otherwise used in that state, or B, in any other case, that is, where it was not contemplated where the goods would be resold or reused, under the law of the state where the buyer has his place of business. So, a couple of questions about this, which I'm not going to answer. You have to answer them. What is the difference between a right or claim? Article 42.1 says the seller must deliver goods free of any right or claim. What is the difference between those two things? Note also the requirement that the right or claim must arise under the law of a particular state as designated there. That would have to be established in order to establish a violation of Article 42, a third party's right or claim. Note also the notice that there's a notice requirement imposed on claimant. It's imposed by CISG Article 43.1, and there is also an exception to that notice requirement in CISG Article 43.2. I think it's worthwhile taking a look at those, making sure that you cover all of your bases. Now, I will note that under U.S. domestic sales law, which is Article 2 of our Uniform Commercial Code, the mere threat of a possible claim against a buyer has been held to be a violation of the warranty of title in Section 2312.1 of the UCC. Here's a comment to that section, one of the official comments, the status of which is not clear. Comment 1 to Section 2312 states, subsection 1 makes provision for a buyer's basic needs in respect of a title, which he in good faith expects to acquire by his purchase, namely that he receive a good, clean title transferred to him also in a rightful manner, so that he will not be exposed to a lawsuit in order to protect it. I've added emphasis there. And U.S. case law supports this idea. It has been held that a buyer who, because of a claim that clouded its title, was put to expense to defend its title, and if it successfully defended the title, proved that it was in fact the owner of the goods. U.S. case law has said, but that the cost of that defense can be a damages recoverable for a breach of the warranty of title under U.S. law. Now, U.S. law obviously is not particularly relevant in this case. Just a little background that may help you understand what's going on here. I will note that U.S. case law also limits this rule that even an invalid claim to title can constitute a breach of the seller's warranty of title. U.S. case law limits this rule to only a colorable claim by a third party against the buyer. Clearly invalid or spurious claims do not constitute a violation of the seller's obligation. Now, even if a mere claim, one that turns out to be unsuccessful or may turn out to be unsuccessful, of intellectual property infringement can constitute a violation of a seller's obligation under CSG Article 42.1, a further issue is how much probability of success must the claim have in order to constitute a violation. I mean, after all, seller surely is not responsible for every possible claim, no matter how spurious. I give you an example. Quote, little green moon people granted me a patent on the goods, and you're violating my patent by using the goods, buyer. That seems like a pretty spurious claim. And such a claim, even if it costs money for the buyer to defend against, or at least under the U.S. winner does not take all system in terms of attorney fees, even though it might cost the buyer money to get that dismissed, the seller is not responsible for these kind of bizarre, spurious claims. Claimant's notice of arbitration, paragraph 27 on record page 8, asserts, quote, the mere claim of a third party which is not completely baseless is sufficient to render the goods non-conforming in the sense of Article 42.1 of CISG. My question is, where does this not completely baseless standard come from, and is it supported by authority? There is also a question raised by both parties' filings, whether there is a violation of Article 42 if the buyer has adequate means to litigate the merits of an intellectual property claim that a third party might make, so that say, if the buyer has the means to litigate that, only if the claim is declared valid would Article 42 be violated. My question about that is, wouldn't even a successful defense against an intellectual property claim still involve expense for the buyer, at least in the U.S. winner does not take all kind of system? Well, that is the take I have, a very preliminary basis of the substantive issues in the 28th vis moot, and I will be joining you in a future class if you have any questions about what I have raised, and I wish you good luck. I think it's going to be a challenging but fun set of issues to address. Thanks. I don't believe it.